Hello students, very good evening to all of you. So in today's class, we are going to discuss a very relevant chapter. And in this lecture, recently, few information about the precedents are in news. For example, the ordinance making power to promulgate the ordinances. So today we are going to discuss that very topic, that is power to promulgate the ordinances. Precedents, power to promulgate the ordinances. We will try to understand all the major facts, dimensions about the issuance of the ordinances. So, firstly, try to understand what is the meaning of ordinance and how it is different from the lawmaking authority of the parliament, right? So, ordinances are few dimensions here we will discuss. Suppose ki the first one, what is ordinance? What is ordinance? A basic definition here we will try to understand. The second, then constitutional context. What are the constitutional context? Means which part, which constitutional article is responsible for this. Thereafter, the features of constitution, the features of ordinances, right? Thereafter, certain limitations, a constitutional limitations over the limitations on the ordinance making power of president. Okay, so these are few dimensions, or apart from it we can also add one more dimension, that is a certain latest ordinance. Okay, and in this category here, one important ordinance which is prevalent in news, and that is the strength of the judges of Supreme Court has been increased by ordinance of president in May 2026, right? So these are the dimensions we will try to understand. We will also discuss what type of question UPSC has been asking over these pattern. What is new pattern? Yeah, what type of things we need to understand so that we can make a clear distinction about the things. What is ordinance? How, why it was constituted? What are the historical roots from where the Indian Constitution or the Constituent Assembly has derived this power of promulgation of ordinances? Yeah, what type of situations it is dealing? What are the interpretation of Supreme Court over it? So these are the major parameters with which we will try to understand. So here I'm covering. So what is ordinance? What is ordinance? What is ordinance? Okay, as we know, a simple meaning, just try to understand ki there is a Parliament of India. Got it? Parliament of India. But before it, we will try to understand the organs of government, right? There are three organs of the government: one, legislature, executive, and judiciary. Every organ is working or performing its functions. Executive, legislature. So the major task of the legislature is to the enactment of the laws, making of the laws. So the law making task has been assigned to the legislature, which is performed by the Parliament of India. Thereafter, the laws are executed by the executive branch of the government. Thereafter, the check and balance has been taken care by the judiciary. It is including, actually Indian judiciary is integrated. It is including Supreme Court plus High Court plus subordinate courts, district and all types of courts are coming within this criteria, right? So sometimes there are certain situations occurs when lawmaking became a important matter, but Supreme Court, but the parliament is not in session. So in these circumstances, how we can deal with the situations? So in order to deal with certain emergency situations, certain urgency, there is a provision in Indian Constitution, that is ordinance making, right? So this is ordinance making. It is mentioning under Article 123 of Indian Constitution, where president or governor in the state concerned, but here we will discuss only the in context of president. It is important for us, right? Equally important that also, but we'll deal later that. So ordinance under Article 123. So ordinance means what? Ordinance means ki it is a temporary power of executive to make laws in certain emergency situations or in order to deal with certain emergency or certain urgency, right? It is a temporary law, executive power of making law. As I have explained, कि majorly the task of law making is assigned to the legislature, means the Parliament of India. But sometimes Parliament is not in session, means during the recess of Parliament and situations occurs, law making process is mandatory. We cannot wait for the reassembly of the Parliament. So in this situation, there is a provision our Constituent Assembly has been provided with us in our Constitution of India to deal with, and that power is, that authority is ordinance making, right? So it is mainly, we can say ki it is a legislative intervention by the executive. So in a very simple terms we can say it is what? So ordinance means it is a legislative, it is a legislative intervention, basically intervention by executive. It means sometimes when Parliament is not in session, executive branch of the government got the authority to make the law, to make the laws, right? And even Supreme Court also said that authority of promulgation of ordinance is associated with executive only in certain urgency basis. It is not a regular power. It is not a regular power. Only during the recess of Parliament this power could be used, right? So here the meaning, it is the executive, right, where lawmaking authority they are using. So here executive means who is using this power on behalf of whom, right? So here president is using this power on the aid and advice of council of ministers, right? So this president is using this promulgation of ordinances on the aid and advice of council of ministers. It means what? It means ki ordinance promulgation is not a discretionary power of the president, right? It is only on the aid and advice of the council of ministers dependence. Got it? So these are the ordinance, a basic meaning. We have got the idea about the ordinance. Constitutional context we have understood along with simultaneously under Article 123. So here try to understand ki what are the circumstances when these ordinances can be issued. So what are those circumstances? So we will try to understand this in as a feature. Yeah, what are the features? Yeah, what are the circumstances? The first circumstance here, when Parliament is in session. When Parliament is not in session. We can also call it as recess period. We can call it as recess period. Okay. Second, if president satisfaction is justified, is president's satisfaction is justified. This is also circumstances prevailed over before the promulgation of the ordinances. I will explain it. What do you mean by president's satisfaction? So, president is acting upon the promulgation of ordinances only on the aid and advice of council of ministers, right? So here, what type of another options available with the president? Suppose ki president is getting aid and advice of council of minister. So after getting, suppose ki president is not getting satisfied with the aid and advice of the president, council of ministers, right? So in these circumstances, that advice of council of ministers could be sent back to the council of ministers for reconsideration, right? Ki I am not satisfied, suppose ki president is returning, just like on the legislative bills, president has three veto powers now: absolute veto, suspensive veto, pocket veto. So under the veto power of suspension, the bill was sent for the reconsideration of the houses na. So in the same way, president has also the power to resend the advice of council of ministers for its reconsideration, that please reconsider your advice about the making or promulgation of the ordinances. Suppose regarding ordinance making, president is reconsidering, right, or sending the advice back to the council of ministers. So in this condition, so president has this discretionary power. President can send the advice of council of ministers for reconsideration. This is discretionary power. But after sending, if again council of ministers is sending the advice to issue the ordinance on a particular topic in order to deal with a certain situation, so in that situation, what could be done? So here, president is bound. So in this situation here, president is bound to accept the offer, to accept the advice. Then he cannot make any reconsideration. Got it? So this thing we have to keep in our mind, because now UPSC has gone through the deep roots of every aspect, of every concept, right? Suppose ki we are just reading only the upper things, that ordinance issuance has been done only on the aid and advice of the council of ministers. It is not a discretionary power. But what about more? So to some more large extent, we have to try certain more depth in the concept so that we can solve the questions of UPSC, right? So this thing. And the second thing, third thing here, uh, promulgation is subjected, means ordinances are subject to, ordinance is subject to judicial review, subject to judicial review, judicial review, right? So the ordinances issued by the president on the advice of council ministers can be challenged in Supreme Court on the ground of mala fide. What is the ground? So on the ground of mala fide, right? What is the ground of challenge? So ground is mala fide. Matlab here the intention has been checked out. And what is the mala fide intention? Means Supreme Court observed a very important fact about it, ki why this ordinance has been issued, because ordinance has been issued without any parliamentary debate, uh, declaration, or any deliberation, without voting, no discussion has been taken place, right? Because executive is doing this. So Supreme Court observed this fact under the category of judicial review, ki whether government of India has issued this, or executive branch of government has issued this ordinance in order to avoid the parliamentary debate on certain controversial issues. right? If it is found, it means ki you wanted to make laws on those topic where you just wanted to avoid the parliamentary debate and the participation of the opposite party as well. So all these facts are checked by the Supreme Court ki by what intention they are issued, right? So the latest issue we can take about the ordinance issuance, that recently the judges, the strength of the judges of Supreme Court has been increased from 34 to 38 now, including Chief Justice of India. Earlier, this strength was took place in 2019, right? So after 6 years, again this issue has been taken place. But that is not the matter. That is a thing. This is the application. But we have to understand the major things, right? How these are issued. So again, judicial review based on the malified, and malified also check the merits. Means merits, all these things could be avoided to some extent or on a point, but we cannot avoid ki why the parliamentary debate has been avoided, or why the role of the opposition party has been not avoided. Like, so these type of things here we will try to understand, right? For a basic things. Got it? Now, the features here we are covering. What are the features mainly? What are the features? So, features means ki when, what are the circumstances when it could be introduced. So, features means what? Features means what? It means ordinance could be issued on all those topics on which the parliament can make laws. It means कि ordinance making power is not parallel, right? It is not parallel. Got it? Ordinance could be issued. Ordinance could be issued on the same subject, on the same subjects or matters, on the same subjects or matters on which parliament can do, right? Parliament can do. For example, union list, right? And concurrent list. And in certain situations, it could be in the state list as well. Got it? That's why. But one most important point you will keep in your mind, ki ordinance making power is not parallel power of parliament. Got it? It is not a parallel power of parliament, because there are again certain limitations on the ordinance issuance. Okay. First important point here I can highlight that parliament can amend the constitution, right? But through ordinance, constitution cannot be amended, right? So here next point, ordinance, through ordinance constitution cannot be amended. Constitution cannot be amended. Got it? One more point, it can be issued with with retrospective effect. With retrospective effect. With retrospective effect means the effect of the law could be created with back date, with previous date. Suppose today we are living in the age of 2026, so we can also, means the president can issue the ordinance which could give effect from the 2020, 21, 22, means with the previous date. If they wanted to effect anything from the previous back date, past date, it could be possible. Got it? But one point again you have to keep in your mind when you are covering the retrospective effect, through ordinance, right? Through ordinance, with retrospective effect, no criminal laws has been created. It does not mean कि through the retrospective effect ordinance can create a new criminal law. Suppose कि in our Indian constitution we have given a protection that we cannot be punished with back dates. Means uh, criminal or offense should be declared merely on the basis of the law of the time, right? So you cannot create new criminal law basically, है ना, with retrospective effect. Suppose कि uh, in present system, suppose कि in present system criminal laws has not uh, give punishment to below the age of 18 years, as we have witnessed this situation in the case of Damini, Nirbhaya case, है ना. So with ordinance we cannot change this law कि now onwards the criminal offenses can be made out against those persons in rarest of the rare case below the age of 18 years, right? So no criminal, so this point you will mind कि no criminal law, no criminal law, no new criminal law could be initiated with the retrospective law, because law will prevails in India only of the time. If that time allows, means when that law make criminal law. So here criminal law is exception with the retrospective effect. Otherwise, rest of the thing through ordinance we can do anything, right? Even through ordinance we can amend the central government acts, laws, amend, repeal, anything could be done except the amendment of constitution. Got it? Next point, president is empowered to issue the ordinance. Suppose ki impeachment, one more provision or dimension we can also add here, ki if suppose ki impeachment procedure is pending against president in the parliament, then in that situation president is empowered to issue the ordinance. So we have to think about it, right? So in this situation the answer is no, right? So there are certain exceptions. Suppose constitution cannot be amended and with retrospective effect no new criminal laws has been created because it will infringe the fundamental rights. And separately we can also give a view ki through the amendment, through the ordinance, fundamental rights, even the basic structure of the constitution cannot be touched by it, right? So these are certain major things which we will keep into our mind ki what the ordinance can do or don't do, right? So here we need to understand what does the ordinance means exactly in Indian constitution. Got it? And suppose ki one more few facts if we know ki what is the maximum life of the ordinance. So the maximum life of ordinance is, maximum life of ordinance is, of ordinance is 6 months, right? And minimum means validity we can also consider it. What is the minimum life means validity here. It does not mean it's a somebody individual. Ordinance does not mean some subject, right? Minimum is 6 weeks. So again one more thing, it has a limitation, right? So why the maximum validity of an ordinance is 6 months? Because in Indian constitution it has been prescribed that there could not be gap more than 6 months between two sessions of the parliament, right? So within 6 months, suppose ki it cannot exceed 6 months one day. If it happens, suppose ki the reassembly of the parliament could not take place within 6 months, so what happened? Lok Sabha could be dissolved by the president, right? And the dissolution of Lok Sabha is totally and totally uh, a discretionary power of the president. It is not based on the aid and advice of the Council of Ministers, right? Got it? So this point. So what happened? Suppose ki a ordinance has been issued, right? Ordinance has been issued. Suppose ki we are taking the latest example. Recently, Parliament is not in session. Parliament is in recess. Recess means a temporary break. And through ordinance, the strength of the judges of Supreme Court has been increased from 34 to 38. It is operative, still operative, right? But it was subject to the approval of Parliament, right? Maximum it will operative in for the 6 months. Got it? It is subject to the approval of Parliament. Got? Suppose ki Parliament is sitting, right? So when Parliament is sitting means reassembly of the Parliament took place the day on which, suppose ki from the 6th of July 2026, the Parliament reassembled for the monsoon session. Got it? So what happened? So within 6 weeks, the ordinance must be approved within 6 weeks from the date of inception of the reassembly of the Lok Sabha or Parliament. It is mandatory it is mandatory to approve the ordinance within 6 week, not months, 6 weeks. You will so maximum for 6 months because of the time period has been prescribed. Got it? And minimum 6 weeks. So from the date of reassembly of the Parliament, it required for 6 weeks, right? Suppose ki after the reassembly, Parliament has not approved the ordinance within the time limit, within 6 weeks, it will automatically ceased. It will collapse. It could also disapproved within this, means within this 6 weeks, approval is possible, disapproval, both approval and disapproval, both. Got it? If not approved within 6 months, so after the expiration of 6 weeks, it became inoperative, right? And two more point here we will also keep in our mind. Because I have think about it, ki suppose this happens, because questions are situational, circumstances. Suppose ki these facts we have memorized, right? So what happened when the certain circumstances or certain conditions are associated or attached with the concepts? Because now UPSC has going on that pattern, so we require to understand the things to a large extent of the depth of the concepts. Suppose ki here approval, disapproval, okay, got it. Next thing, ki president has the power to ordinance issuance. So can the president has the power to withdraw? Yes, withdraw. So president has the power to withdraw. President can withdraw ordinance anytime, okay? If it is withdrawal, then it will finished, nothing. Then there is not required to put all the ordinances in front of the Parliament when it got reassembled in the next session, not required, finish. Got it? The next circumstances here, ki suppose assembly or Parliament after the reassembly is disapproved, the ordinance means the ordinance which are disapproved by the Parliament, is there any constitutional validity or constitutional provisions to re-promulgate those ordinances which are rejected by Parliament? Means what are the constitutional validity? Suppose ki Parliament has rejected any ordinance, right? So what are the conditions? Means, can the disapproved ordinances are reissued by president? This is question mark, right? Ki disapproved ordinances are reissued or repromulgated by the president? Same. So answer is yes. Okay. Answer is yes. Suppose ki UPSC is asking a question over the prelims ki consider the following statement with respect to the promulgation of the ordinance by the president, right? So the first statement they are writing ki parliament disapproved those ordinance, they cannot be re-promulgated or reissued in any situations. ये स्टेटमेंट गलत हो जाएगी, ठीक है? तो those could be reissued, re-promulgate even after the disapproval of parliament. Got it? Okay. And again I am telling you ki the power to promulgate ordinance is subject to judicial review, right? In 1970 mainly. So what is the judicial intervention here? I'm just describing. What is judicial intervention regarding this power of ordinance? So the first thing here, Supreme Court views out in 1970 case was there. It has been said ki ordinance issuance is subject to judicial review on the ground of it can be challenged in the Supreme Court on the ground of malafide, right? But what happened in 38th Constitutional Amendment Act was passed in 1975. Got it? And here it has been a provision has been made under this Amendment Act ki judicial review cannot be possible in the ordinance issuance, right? But this provision has been deleted by the 44th Constitutional Amendment Act 1978, right? This thing. Got it? And if I talk about certain historical perspectives, ki initially, because just like the RBI Hilton Younger Hunter Commission, RBI history and economy has been connected, right? So in the same way, we can also utilize certain historical facts. So the first time in Indian history, when the ordinances were issued and by which act the ordinance issuance power was granted to viceroy or the governor general. So our answer is after the when 1857 revolt took place, thereafter the Indian Councils Act 1861 was passed out. So first time the ordinance making authority to viceroy has been granted in order to raise the status of viceroy, means in order to deal with certain emergency situations, right? We can utilize this power. It is a law making authority, we can deal with that. One more point again I'm here telling you. Suppose ki I gave you a few things ki it cannot be uh, issued on the same matlab constitution amendment cannot be done. One more thing ki ordinance cannot be issued during national emergency. One more fact here you can also add, although it could be used in order to deal a emergency situation, but not a national emergency, because the national emergency is something else. It is a bigger concept where the federal structure became the unitary, right? So here I'm just dealing. So even this circumstances, so ordinances cannot, and they also cannot be issued during the national emergency. Got it? Because at that time parliament became, it cannot go on recess, right? It became the whole supreme authority in India. Got it? uh, so in 1861 So in 1861, where the viceroy was granted with the uh, ordinance authority. Thereafter, in 1935, the Governor General of India was granted with the power to issue ordinances. And from here, the Constituent Assembly inherited, we have derived this power from the 1935 Act. That's why we have included this power in the Indian Constitution, right? So overall, if I gave a review, ki why the this urgent situations, the promulgation issue has been granted to the president. So the answer is very simple, ki India is a very multipolarity country, multi-diverse country, uh, country of so much diversity. So urgency situation could be come from any side of the India. It could be come from northeast, North India, West India, South India. So in order to deal with, or in order to deal the interests of certain specific community, certain specific area of the India, or of national importance, so they could be used, right? So they can utilize it, right? And I think all the things we have discussed in this lecture, so this is important and this is more than enough for us, right? I have only gone through the important points here, not a very much detail, because it will take otherwise no more time. Got it? So thank you so much. Take care.